Okay, hey guys, this is the court's lecture 3, so it's notes 7 through 9, all right? It's all about the Supreme Court, all right? So this is day 3, right? Okay, so this is just about the Supreme Court, and so we'll just get into some nuts and bolts. We'll get into a couple little kind of complex things, and then we will be done, all right? Okay, so now remember, and we've already talked about this, that it's an Article 3 court, that it is the only court specifically mentioned in the Constitution, right? Like, remember that the Constitution says that all other courts can be created by Congress, all other inferior courts, right? So there's 8 associate justices and 1 chief justice, so for a total of 9, right? The number of justices is set by Congress, right? It's been 9 for quite some time. I think it originally was 6, and it's kind of evolved, all right? I know that, remember the court packing scheme of FDR, that FDR had threatened, he's like, I'm going to ask Congress to get more judges on there so I can get decisions that I want, all right? It never happened, but Congress determines the number of judges, all right? Now, here's the deal. Whenever there's a vacancy in the Supreme Court, the President of the United States will nominate someone, and they'll have to go through confirmation in the Senate Judiciary Committee, right? And then the Senate Judiciary Committee will send that to the floor where there can be a debate on whether or not to confirm them with a simple majority vote. All right? Now, the Chief Justice, all right? The Chief Justice is, I think the kind of line is he's the most equal, all right? I mean, the Chief Justice definitely has some other powers, but the reality is he's one of, or right now he is one of 9 votes. John Roberts is one of 9 votes, okay? So really, I mean, they have some power, but the Chief Justice is an equal. All right, now again, we talked about this idea that it's the highest court in the land, right? You've come from the state Supreme Courts, you've come from the district circuit courts up to the Supreme Court, and that's it, right? At this point, their decision is the court of last resort. Now again, more even just kind of review, which is nice, is their key power is judicial review, right? Marbury v. Madison says that the Supreme Court has the power to strike down laws that are repugnant to the Constitution, right? And we've read Federalist 78, that is the peculiar province of the courts to strike down laws that violate the tenor, the manifest tenor of the Constitution, the highest law in the land, right? Now, originally Marbury v. Madison said federal laws can be struck down, right? And then you get a case called Martin versus Hunter's Lessee, right? That'll be extra credit today, all right? Extra credit on this is Martin versus Hunter's Lessee. And what that case did is that said that state laws that are contradictory to the Constitution can be struck down by the Supreme Court as well. All right? Okay, now the other thing is, again, their power to interpret the Constitution and their power to interpret broadly worded laws by Congress are incredibly important powers, right? So striking things down, defining the Constitution, defining broadly worded laws given to them. And then the other thing is this, is they can overturn precedents, right? Remember we talked about this idea of stare decisis, let the decision stand. Judges are constantly or trying to use previous decisions in their current decision because they know that gives consistency, right? And a good decision, you know, a good precedent gives a good interpretation of the Constitution. However, if these precedents end up, you know, violating the Constitution at this point, like later, right, the justices believe that, then they can overturn those precedents, all right? But stare decisis is something they like to use, all right? Letting the decision stand, using previous decisions. However, if, again, they feel that the action in front of them is unconstitutional, they can disregard that precedent, all right, and establish a new precedent. Like we talked about Plessy v. Ferguson to Brown v. Board. Separate but equal is the precedent said in Plessy, and that's absolutely struck down and given a new definition in Brown v. Board. All right, so the Supreme Court's jurisdiction, right, they have both original and appellate. Now, very, very rarely do they get cases on original jurisdiction. They almost always are going to be, the vast majority will be from appellate jurisdiction, all right? And remember, they come, again, on appellate from the circuit courts, right, and from the state Supreme Courts to the Supreme Court, right, the federal Supreme Court. Now, they have original jurisdiction when we have multiple states involved, and then we have ambassadors involved. That's generally the only time they'll have original jurisdiction. All other times, it's on appellate jurisdiction, all right? So now we got to look about how a case gets there in the first place. So the Supreme Court sets its own docket, which means they decide which cases they're going to put. A docket is a list of cases they'll hear, all right? And they decide which ones they want to take, all right? And you know, we talked about this. There's roughly 80 to 90 cases a year accepted to the Supreme Court, all right? Of the 100 million cases in this country, right, 8,000 to 9,000 asked for, the Supreme Court to hear their case, and 80 to 90 hear it, right? This can change. It can be less. It can be a little bit more, depending on the court, all right? Now, here's the deal. The rule of 4. So the goal is this, is if you want the Supreme Court to hear your case, you need 4 justices to take your paperwork and say, we want to hear it. So this is the one case in which a minority actually can win in this case, right? And here's the deal. They may say no to your case if you don't have a federal issue. You know, if the party doesn't have any standing, if they agree with the decision of a lower court, right? They've already made a ruling. You know, maybe there's a previous decision that stands and that precedent's good, and the lower courts, meaning the district court or the circuit court, has made a ruling according to that precedent, and the Supreme Court's like, yeah, they got it right. We don't need to hear this. That decision is correct, all right? Now, they may take it because there is a big federal issue. You know, you have multiple circuit courts or multiple district courts or multiple state courts getting this part of the Constitution very different. They may want to hear it. It may be time to hear it, right? Now, that rule of 4 is you're trying to get a writ of certiorari, right? A writ of cert. If they give you a writ of cert, think of it as Charlie and the Chocolate Factory, that golden ticket, right? If they give you that golden ticket, they're going to hear your case, and that's the rule of 4, all right? But again, they only take those cases they believe that are the most pressing, that can have the biggest impact on the legal system in our country, all right? Okay. Now, here's the thing. When they do accept your case, they can do 2 things. They can say, we read your briefs, right? Like you submit documents with your case, you know, the whole decisions of the lower courts, your argument, you're basically this big persuasive essay, all right? And they can read it and they can say, you know what? We don't even have to hear your argument. Based on these documents, we know how we're going to rule. And that's called a per curiam opinion, all right? Or they can say, give us your documents, we read the documents, and we want to hear oral arguments from you and the other side. All right? Does that make sense? So the oral arguments, now we're going to get into this in just a second. So they can either write a per curiam opinion where they say, we have enough information, we don't even need to hear from you, we'll make our decision, here you go. Or they can say, we want to hear from you in oral arguments. All right? So look at the Supreme Court really quickly here. October to June, they hear cases Monday through Thursday, a quorum of 6, which means a minimum number of 6 justices need to be present to hear a case to it formally to be decided, all right? Now, oral arguments. Here's what they do. Before oral arguments, the justices will read the attorney's briefs, which is their argument why it should be ruled a certain way. Their law clerks that work for the Supreme Court will read arguments with them, or the briefs, and they'll understand the issue, all right? Judges will also read amicus briefs. Remember, we learned about those back in interest groups, right? All these groups that may be involved in this decision, or maybe they're not directly involved, but they know that they'll be impacted by the decision, will write amicus briefs, friend of the court briefs, in which they're trying to write a persuasive essay to the Supreme Court to rule a certain way. So they'll get all that information, they'll read it, all right? And they've already decided in the Rule of 4 to hear your case. Then what they'll do is they'll have 30 minutes on each side. And you get 30 minutes to make your argument, all right? And what you'll find is that attorneys, this is the Super Bowl, right? You're arguing in front of the Supreme Court. They get 30 minutes, and lawyers will prepare to give a 30-minute argument, but really what quickly happens is the justices just start asking you questions, and you have to respond to their questions. Because the reason they want to ask you questions is they want to clarify. They want to try to understand the issue, and they want to gain information to help them understand how they're going to vote. All right? Okay. Now, after they've heard your oral arguments and time's up, then you go away, they go away. On Fridays, they have a Friday conference. And on this Friday conference, it's only the 9 justices, and they meet. The most junior justice takes notes, right? Nobody can be in there, you know, because I think they just want that private conversation to freely and discuss, all right? And then they vote. They'll literally say, okay, you know, the case of, you know, Barry v. whatever, right? Like, okay, let's have a discussion. They'll have a discussion. Everyone will say their piece, and they'll vote. All right, and this is not the end result vote. All they're saying is, okay, where are we at? And so let's say it's 5-4. 5 justices for, 4 justices against. All right? Then they will talk about opinions. Now let's look at the types of opinions. We'll get into the purpose in just a second. You have unanimous opinions, majority opinions, dissenting opinions, and concurring opinions. Unanimous means 9-0 decision. 9 of them agree. Now these are the most powerful because it means there's a clearly an interpretation of the Constitution or clearly a strong precedent being set. Right? You got to understand this. If a decision is a 5-4 majority, right, that's a weaker precedent than say an 8-1, a 7-2, a 9-0. Right? You got to think Brown v. Board was 9-0. If that decision had been 5-4, the South would have fought it longer, right? But because it was so profoundly, you know, unanimous 9-0, that's what the country felt, then the South couldn't fight it, right? Okay. Now, the unanimous opinion, 9-0. Then you have a majority opinion, which could be anything under that. 8-1, 7-2, 6-3, 5-4. All right? The 8, the 7, the 6, and the 5 is the majority opinion. And what they basically do is they tell you why they came to their conclusion. What is their reasoning? What is their logic? How they've interpreted the Constitution. They've given their reason why they've ruled this certain way, okay? Now, the dissenting opinion is essentially, you can think of it as the minority opinion, all right? Like, basically what they do is they say, this is why the majority is wrong. This is why we need to vote the other way. All right? They're giving you their legal, constitutional, intellectual reasoning for why they disagreed with the majority. Now, what you'll see in your notes is quite often, if a precedent is overturned, like down the road, quite often that precedent, when it's being overturned, they'll use the minority opinion or the dissenting opinion in that previous decision. So in Brown v. Board, when they overturned Plessy, they quoted some of the dissenting opinion from Plessy, which is why they got it wrong, and they use that in this new majority opinion to overturn Plessy. All right? Because they probably have similar arguments. They don't always have to, but it can. Now, here's a concurring opinion. So let's say we have a 6-3 vote, right? You have a majority opinion which says this is what the majority thinks, but you as a justice could say, I agree with the outcome, 6-3, but I agree for different reasons. And you could write what's called a concurring opinion, your own opinion. Now this, again, is a weaker precedent because then you have people agreeing with the outcome, but for different reasons. And so maybe it's not as clarifying as ideally it could have been. All right? Okay. Now, let's look at this a little bit. If the Chief Justice is in the majority, he can assign someone to write the majority opinion, or he can write the opinion. All right? All right. Now, think about the politics of writing the opinion. You want someone who can put a slant on it, write it persuasively, write it in the manner in which you agree. So lots of times the Chief Justice, just by choosing who gets to write it or choosing to write it himself, can kind of determine the flavor of that opinion. Because again, you don't want to get splits. You don't want concurring opinions. You don't want dissenting opinions. Ideally, your goal is to have 9-0 every time. But if you get like a 5-4, you have to write it in such a way that is 5 all in the majority opinion, 4 against it. You don't want to have 5-4, but then have 4 people on a majority opinion and then 1 on a concurring opinion because it weakens your opinion. All right? Now, again, when you structure a majority opinion, you got to think about this. We all agree that the outcome is here, but they all have to agree on the logic that gets you to that outcome. So when you write the opinion, you have to write it in a way which keeps that voting block together. Or some people could jump ship and say, I'm going to write my own concurring opinion, or I totally now disagree with what you're saying and I can't sign on to that opinion. I'm going to go with the minority, and that could change the outcome of the whole vote, right? They could go sign on with the minority opinion, which could flip the outcome. Because the vote is not final until the majority opinion is signed and it's formally released, all right? Like the debate, the intellectual debate. And what you got to understand is these guys are writing these rough drafts and sharing it. Like you'll write a majority opinion, send it to everyone in the majority, and they're commenting on it. They're making changes to it. They're having discussions about it to get it just right. All right? Now, and again, the threat of a dissenting opinion can really force someone to change the majority a little bit to keep that coalition together. All right? Now, the purpose of opinion. Number one, it tells the court, the public, why the court was thinking what they were. It gives them the reasoning behind their decision. All right? It also establishes a precedent. So when judges coming down the road get similar cases on the similar issue, either at the district courts, at the circuit courts, in the state courts, or even future Supreme Courts, the Supreme Court won't hear it if they already feel there's a good precedent, right? But they communicate, basically, here's our reasoning, and if it's good reasoning, they'll use it in stare decisis, or you letting the decision stand, right? Like, the dream is that you get these opinions written that are so clear and so eloquent that they define the Constitution, they define the law, so that when lower courts hear cases of a similar nature, rather than coming up with their new precedent, they simply look to the precedent set in that opinion. They use that as a guidance on how to make their ruling, right? Now, again, they can always contradict it, all right? And then finally, this idea of dropping hints, right? Like what the Supreme Court can say is, right now we're striking this down as unconstitutional. However, if it had been written in this way, this way, this way, or this way, we wouldn't have no problem with it. And so what that does is that's giving a hint to the Congress or to a state legislature that they rewrite the law in a certain way, it could be upheld. All right? Now, you also have to understand that people that write laws are going to be thinking, like, how would the court rule if this is potentially unconstitutional? Like, how can we avoid even getting into the courts? Because ideally, you don't want to get into the courts. Unless you're purposely challenging an existing precedent and you do something because you want that precedent overturned, right? Because the makeup of the court could change. Like Brown v. Board was brought before the court because they wanted to overturn that previous decision. It was a purposeful action to get that in there because they wanted to challenge, because they knew they were going to lose at the legislative level in the South, so they had to try to win at the judicial level, right? So they wanted to overturn that precedent. All right? Okay. Now, let's move on to, just really quickly, like evading the court, right? We've talked about this a little bit. The way you get around the court, if you don't like their decision, you can amend the Constitution. And you can make whatever you wrote in that law about that action, you can make it part of the Constitution. They can't rule it as unconstitutional. But we know the difficulty in that, right? Okay. Now, here's the other thing, is people can ignore the decisions, right? This idea that the Supreme Court, 9 people can't be everywhere at every moment, right? So maybe their precedent isn't being followed perfectly. So sometimes there's wiggle room because we live in a country, of roughly 300-something million people, and there's things going on a daily basis the Supreme Court doesn't hear about, right? I guess we depend upon the executive branch. We depend upon the law enforcement agents. We depend upon the media to cover this stuff to make sure that these things aren't being violated, right? But I mean, look at this quote. The Constitution may be what the Supreme Court says it is, but really, it's what a policeman, a school board, or a city council says it is. If they allow certain things to happen and it doesn't make it to the Supreme Court, like they're noticed or that people don't notice about it, then it can be, they could ignore the court, right? Okay. So, remember, they have neither the purse nor the sword, but merely judgment, right? That they're dependent upon the other branches of enforcing their legislation, all right? Or their decisions. All right, now really quickly, the names, all right? If we think about this, we got to figure out how to learn the liberals, the conservatives, and the moderates. Right now we have Sotomayor, Kagan, Ginsburg, and Breyer are all kind of the liberal bloc, right? And then we have 4 more, which are Roberts, Scalia, Thomas, and Alito, which are the conservative bloc. And then we have Anthony Kennedy, who's considered the swing vote. Now, most of the time, Anthony Kennedy votes with the conservatives. However, on some issues, he can vote with the liberals. All right? And it's interesting, right? Like we said that the president nominates somebody of their own ideology, ideally. But, John Roberts, who's conservative and appointed by George Bush, actually voted to uphold the Affordable Care Act, right? Which we generally would have thought as well, if he's a conservative, he would have been against that. So we can't always predict exactly how they're going to vote. All right? All right, so I would say this. All those justices this time on this quiz are extra credit, but the next time I think I need you to know the justices, all right? All right, so, hey, one way I know there's no vowels in the first letter of the liberals, right? Bader, Breyer, you can think of like Bricks, B-R-K-S, right? Bader, Ruth Bader Ginsburg, I don't know, you got to figure that one out. The conservatives, though, you can spell star. Thomas, Alito, Roberts, and Scalia, all right? I mean, just try to figure it out. It's extra credit this time, all right? Do the vocab, ask me questions, watch this lecture, okay, bye.